From a man who terrorized his ex with death threats while stockpiling 200 rounds of ammunition.
In his text, he says things like, "You've got one time to tell me who you're with before I start blowing. You're on some sneaky shit. I'm finna start shooting. I'm finna kill you personally for playing with me like this. Or you want everyone to die. Do I have to call again or blow this bitch down? You're dying tonight. Answer the phone because now I'm killing you."
To another who swears he has no idea how drugs ended up in his system.
I guess my question is he saying it shouldn't be in his system at all?
That's what he's saying, Your Honor.
Yeah, I did not knowingly ingest THC, but I do have a medical card.
This says you report not having one. So you were just somewhere and this THC snuck into your system.
These cases show that Judge Simpson isn't up for any excuses. Starting with Mr. Campbell, who went from stalking to violent threats, doing everything possible to make his ex's life a living hell. Let's watch how that works out for him.
Court calls case of People versus Campbell.
And then on behalf of people,
Public Defender Buckovich on behalf of Mr. Campbell, who's now approaching.
Nelson Campbell.
All right. I set this date because the people had filed an emergency motion regarding the defendant's bond. We addressed it, was it Tuesday? I think it was. We addressed it on Tuesday, believing the defendant to be out of custody because he'd been released on a PR with a tether. As I'm to understand, he didn't get the tether. The tether had to be put on him prior to release. So actually, during that whole process, he was sitting in Washington jail. He had not been released. At that time, and I think we've not entered the bench warrant, certainly in the case, but I had increased his bond to $100,000 in each of the two cases that I had. Now I have three. So that's where we are.
Yes, Your Honor.
So you've had an opportunity to look at the people's motion regarding bond.
Yes, I have, Your
Do you
Honor.
have a response?
Yes, Your Honor. In addressing a bond, some facts about my client, he wanted to share that he is a student at Ypsilanti High School, currently working a full-time job at Comtech as a forklift operator. He's expecting his first child on February 28th, and he mentors youth throughout Ypsilanti. He denies the allegations of any improper contact with the complaining witness or any other party or committing any threatening behavior. He has a supportive family system, and he has an knowledge that in the past, in other cases, he has been successful on tether, so he is not a flight risk. So,
all right. Respond to the people.
Your Honor, in large part, we would rely on our motion. I just wanted to add a few new things and other things for these multitude of cases. This defendant is currently looking at a case for larceny of building, case for trespassing, for a maluse, a case for aggravated stalking and maluse, a case for ammo possession by prohibited person, a case for another maluse against a different victim, another case of reauthorized domestic violence, and then there's one more case floating that we had to further get more information that will most likely be for an intimidation in relation to that dismissed reauthorized domestic violence case. He's probably looking at a lot of different things, and I have extreme concerns about this defendant and his escalation in his behavior towards this victim. In this case, I didn't just put this in the motion, but the text related to the aggravated stalking are extremely concerning. In his text, he says things like, "You've got one time to tell me who you're with before I start blowing. You're on some sneaky shit. I'm finna start shooting. I'm finna kill you personally for playing with me like this. Or you want everyone to die. Do I have to call again or blow this bitch down? You're dying tonight. Answer the phone because now I'm killing you. And if you come out, I'm gonna wait for you. Now come out or I'm coming in forcefully." Among that, on his own personal YouTube channel, as well as his Instagram, he has numerous pictures of him with different firearms that weren't recovered during the search warrant. Only over 200 rounds of ammo were recovered. I have extreme concerns that he would still be able to access firearms and carry out these threats against his victim, who is his ex-girlfriend. I have extreme concerns given that, especially with the new cases coming forward for this defendant. Beyond that, I know he has a previous adjudication for GBH in which he shot a different victim in the ankle, so this gives me even greater concern that he would carry out these threats against this victim. She lives in extreme fear. She's afraid to leave her apartment due to the fear that he'd be waiting outside. She only leaves for school, and even then, she's extremely frightened to leave, fearing that he would be outside waiting for her in his car, that he would break into her apartment, things of that nature. I just have an extreme concern given the escalation, and that ammo was found in his house and no guns were found or have been get turned over to law enforcement, especially with him posting on social media holding different guns. I just have extreme concerns with all of these cases for her safety, as well as her friends or family who he also threatens in text.
Anything additional from
In relation to the guns in the YouTube videos, my client has acknowledged that they are fake prop weapons.
they fake prop weapons?
Yes.
Then having said that, can you explain the 200 rounds in his house and where the weapons are that they belong to?
My granddad has owned the house for about 50 years and owned rifles, guns, and ammunition, but I did not know. He passed away in 2016, and I had no prior knowledge that anything was still left in my grandfather's house, sir.
I do believe in the police report it states that some of the ammo was found next to his bed by his phone. And also, I was just informed previously on the DB case when it was authorized. This wasn't addressed then, the victim didn't show up for court, but he had been calling her from jail on that original case. That was never addressed. So I'm not sure what's exactly in those calls, but I have great concerns that he cannot follow court orders.
That's one of the cases.
And that's that'll be part of the case that's pending for the intimidation that we had to further and are waiting to authorize charges on.
Go ahead.
Yes, Your Honor. Yes, Your Honor. I understand that my client was waiting on another charge today as well. So at this time, he would like me to request that his PR bond be reinstated, or in the alternative, a nominal cash bond, as he does have a cash bond in another case that he was waiting on this afternoon.
I believe that was the domestic violence case. I believe it's 25,000 cash surety on that.
That is
On his DB case?
That was reauthorized, yes. And in these cases, we would be asking for a $150,000 surety bond.
Yeah. Well, in looking at it, the original bonds are set by the magistrate, and it's unclear to me that the magistrate knew everything that was as contained in the motion, but just given the escalation, as the people I think adequately point out, the defendant's behavior. Ms. Wilding?
Yes. She's available.
Huh?
She's available.
Yes. Yeah, let her know, because I think they stopped working in Ann Arbor at like 2. That us in the out county, we keep going till sundown. All right. And it's another day. I don't know why are these judges trying to reach me. What did I do? Hold on one moment. No, he's okay. And this is another judge. Just, I know. All right. In regard to this case, there's certainly an escalation in his behavior. And again, I don't know what the magistrate knew. I do not believe what the defendant is saying, that there's 200 rounds of ammo, but that he has no knowledge of, and that all of these weapons are just props. And like, I don't believe that for one moment. I don't even know why you do that, but certainly the threats as against the alleged victim in this case are grave concern to the court, and the defendant having the ability to carry those threats that he's making out. Court does believe that, first of all, with much regret, because again, I think I'm required to make this finding. I think that the original setting of the PR bonds and the other bonds in these 3 cases that are before me are an abuse of discretion, and the court is going to change those bonds. And I'm not saying that critically. I just think discretion was abused in setting them. There may have been information that the magistrate did not know. And I am going to therefore, I believe also then that it poses a significant threat and risk to the community, and that the defendant would also pose a flight risk if released, but certainly poses a threat to the community, particularly the victim in this case. So in cases I won't raise it or set them as high initially as the people are requesting, but the case ending in 0179 and the case ending in 0193, I'm setting the defendant's bond in the amount of $100,000 cash as surety in each one of those cases. I will move the defendant's current probable cause conference is set for the 27th. I'm moving them up to the 20th.
Understood.
Since I have increased his bond. I mean, yeah, I'm gonna leave them on the 27th. I don't know where I was. Thank you, Ann. That's right, because I was something back 5. And on the other case, I will set his bond, this being the case ending in 0192, also finding an abuse of discretion. I'm going to increase his bond in that case to a $50,000 cash surety bond.
The 0192, which case was that, Your Honor? I apologize.
Which one?
The 0192.
0192, actually, I don't, 0192 is larceny of building.
Okay, thank you, Your Honor.
All right, thank you, folks.
Thank you.
Now we have Mr. Smith, charged with carjacking and assault, yet still out on a PR bond, and instead of staying clean, admits to using drugs.
Court calls the case, People versus Caleb Smith.
Lawrence Margolis on behalf of Mr. Smith. Caleb, please unmute yourself. Please state your name.
Caleb Smith.
Judge, we are still waiting on discovery in this matter. It's through U of M and they are notoriously slow. The video, we got discovery from the people, but I believe we're waiting on the video download from U of M. Is that correct, Mr. Prosecutor?
I missed what the last part of what he said was. I'm sorry.
We are waiting on the discovery download of the video from the U of M Department of Public Safety. I am not in possession of it as of this time. I had spoken with Mr. Chalmers, who was handling this previously. I know he's in trial. Do you have any update for the court on the video?
So I'm not familiar with how long it's going to take for that to be downloaded and sent over to you. I do see it looks like we sent some materials last month. I can reach out to U of M to see if there's a hang up on their end. But that's the best of my knowledge as far as the download and that process.
That'd be great. That's all I could ask for. Thank you.
How much time are you gonna need to?
I can reach out to them today. I'm not sure how long it's going to take them to get back.
I sent that out one for. So, second. Probable cause conference. Go to March 6, 2025, 9 a.m. Or as your invite indicates, bond will continue.
Your Honor, if people may be heard on bond, actually.
Yes, go ahead, sir.
Your Honor, the current bond in this case, I believe, is a PR bond. I would note that people initially requested $25,000 surety. I would be renewing that request. The counts charged here, as the court can see, are carjacking, assault, intent to rob while unarmed, financial transaction device, as well as receiving and concealing. As far as the people's concern, it's public safety, and that this is a defendant who assaulted a completely unknown victim, a stranger, in a parking lot, tried to take her car, took some property from her. She suffered a broken nose, chipped tooth, numerous abrasions. I believe he was then found later with other individuals consuming marijuana despite being under 21. I think that a PR bond is not appropriate given the severity of the charges as well as the facts of this case.
Mr. Margolis.
We'd ask Your Honor to keep the bond in place. This individual was charged originally as a juvenile. He spent 4 days in custody. The case was, he was released. And at the time it was dismissed and then it was recharged. We've been working with the detective in this matter and we turned ourselves in and then were able to get the PR bond. Miss Burton Harris was at that hearing or one of her people were there. I think she was at that one. I can't remember exactly that. Maybe that was Joe. He has no prior criminal history of any sort. He is an A student at Huron High School. He is on a house arrest tether. His mother is in the courtroom or in the Zoom with Mr. Smith today. He is not a threat of committing any crimes. He is not a threat of leaving the jurisdiction. We would ask Your Honor to keep the bond in place. And there's been no bond violations. I don't believe he said something about marijuana.
Is he testing?
I can't recall, Caleb. Are you testing? I think he did test, but I don't know if he is testing presently.
Testing for what? Sorry.
Alcohol or drugs?
No, they're not testing me.
All right, young man, if I tell you to report to community corrections today to take a drug test, is it going to come back clean?
No.
What's going to show up?
Just it was from school. Just marijuana. That's it.
How old are you?
I just turned 18.
Yeah, that's a problem. Mr. Margolis, how fast can you and your client get down to the court?
Half an hour?
Pardon?
1/2 an hour?
Okay, I'll pass the matter. We'll see you then.
Thank you, Judge.
Thank you.
Unlike Smith, here's Mr. Herrera, given a PR bond, but still couldn't stay out of trouble. He drank, violated his bond, and now has a fresh retail fraud charge for stealing alcohol. Crazy, right? Some just refuse to change.
Court does call the case of the people versus Fabian Herrera. Good afternoon, Your Honor. James Fifelski appearing with and on behalf of Mr. Herrera. Can you state your name, please?
My name is Fabian Herrera, Your Honor.
All right. This is your motion for bond reduction. Yes, Your Honor. Mr. Herrera has now been in custody for a little over 2 weeks. Court may recall his bond was revoked for alcohol consumption. I think that was only within a few days of his arraignment after being arrested on this case. I'm asking the court to consider reinstating PR $5,000 bond with whatever additional conditions would secure the court's confidence, including alcohol tether or GPS tether. Mike, this is a case where Mr. Ben-Galil and I are in a serious conversation about potentially resolving, and I'm not going to try to put words into his mouth, but potentially resolving at the district court level. That's one of the reasons we're also asking to adjourn. But Your Honor, my client, I think most compelling in terms of community ties is his mother who has dementia that he would be assisting if he could. She has an apartment, I believe, nearby in Ann Arbor. His fiance is also pregnant and due to have a child within the next month. She is at Delana Center because the only way she could have other housing would be to be with my client at his mother's residence, where he would ultimately, as he was, financially support both of them. So I think his heart is in the right place. He will admit to the court he has struggled with alcohol. And if there is an alcohol dependence, he's more than happy to get into treatment to address that. But I think with all that he's got going on, he had a serious lapse of judgment by drinking. And I'm guessing had been a little overwhelmed by this whole situation. And with professional support and also accountability to the court, drinking should not be an issue if he's also getting some support. But I'm asking the court to recognize, and I'm sure my client does, that the last 2.5 weeks have had a significant impact on him and his level of clarity about how serious it is to comply with the court's bond conditions. And the last thing I'll say, as I noted in the report, I don't think there's any dispute as to the fact that my client was the only one that got injured in this case. There's an allegation he pulled out a knife, but I don't think anybody was touched. So in terms of injury to anyone else besides himself, that did not occur. Again, I would just ask for the court's consideration of all those factors.
Response.
I just recently spoke with a member of my office and learned that it actually has a new warrant submission from February 1st of this year for a retail fraud second. And he is alleged to have taken $200 worth of material, including alcohol, at the time of that incident. The bond originally in this matter was a PR bond, and the concern obviously is the defendant's ability to orders while on bond. The fact that he is now a pending criminal matter being reviewed for charges theft involving alcohol, substance abuse, substance issue in regard to his non-compliance with the bond. In this case, he's of concern to people. I asked the court to keep the bond as is in regards to this particular case. In history, the defendant sustained injuries after he was unsuccessful in his attempts to injure other parties with a box cutter. That is perhaps more the grace of God protecting the complaining witnesses in this case than anything else. However, wishes to view it, the reality is that the defendant had the opportunity to write these charges to be free and to appear for his court.
Well, I don't think he missed any court dates. I think the bond violation was consuming alcohol. If there is a new charge, certainly, I mean, it sounds to me like that followed shortly on the coattails of this arrest, but that can be dealt with in terms of whatever bond issues can be secured there. Again, my client, he does not have any money unless he's working. He was working before he got arrested for this case. The fact that he wants to try to support two of the most important people in his life, I think he was actually at the Delana Center for some period of time prior to this situation. Now he can't go there because one of the complaining witnesses also resides there. So there's a lot of different layers to this, but at the end of the day, I don't think Mr. Herrera has any interest in making contact with those two people. He certainly has no interest other than taking care of his fiance and her upcoming her delivery, as well as his mother, who, from what I understand, and I have spoken to her personally, she continues to support her son and would even, I think, allow him to be bonded out to her house if the court even wanted a GPS tether on top of an alcohol tether.
I think there's going to have to be some other type of plan in place, because while the charge that may be coming may not be, your most extreme or most serious type of charge, the fact that it involves alcohol and the fact he couldn't maintain himself on this case because of alcohol is a clear problem. And the other piece to that is that his behavior becomes what it is when he's drinking. I'll just leave it at that. I'm not trying to make any disparaging remarks. It just is what it is. And that makes him a threat. So I'm not going to change his bond at this time. Mr. Fafowski, if there's some structure or something that can be put in place for him, I realize the resources are limited, then the court would relook at that and reconsider doing something else. I don't really want to hold him, but I also realize he's got a demon that can't be controlled at this point by another means.
Can the court order that he participate in, is it Dawn Farms or CCOP in jail, and then potentially be released on a bond once he has some of that?
I will, if you prepare an order to that effect, to the extent that they'll listen to it.
Okay.
That I don't have any problem with that.
Okay.
Because I think
I'll work on that.
Helpful for him. So the motion for bond reduction tonight, bond will continue with this. I will set this. Did you want me to set it for next week or the 6th, Mr.?
I think it may take a little longer than a week. We're trying to get some surveillance videos from the Blake Transit Center, and it sounds like we've got bits and pieces. So
I'll set it for the 6th, March 6th, 2025 at 9 a.m.
Thank you, Your Honor.
All right. Thank you. I'll try to get treatment in the jail. They'll talk how you two first.
While Mr. Herrera faced consequences for his actions, this time it's Mr. Matthew facing charges of stalking. Let's see how the judge handles this.
Today's people versus Matthew Peschel.
Alexander, on behalf of the people, Your Honor.
Don Sopanis, Your Honor, on behalf of Mr. Peschel. Mr. Peschel, right. My office with me, Your Honor.
All right, where is he? Can you state your name, please, sir?
Matthew Gary Peschel.
All right. I have a plea form. Is that what we're doing today?
Yes, Your Honor.
The plea form indicates that the defendant would be pleading no contest to the charge of stalking, the 1-year offense,
Upon a successful no contest plea to that charge, count one would be dismissed. There is an agreement for sentencing under the prosecutor's deferred and no upfront jail. Although, while I'm taking the plea, I can't bind the sentencing judge, Judge Freshour, to that. I don't see a reason why she may not follow it, but I cannot bind her to that. All right?
Yeah,
That's the court's full understanding of the agreement. Is that correct, counsel?
That's correct for people, Your Honor.
Yes, Your Honor.
All right, very good. All right, Mr. Peschel, can you raise your right hand, please, sir? Where is he? All right. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, state your name again for the record, please.
Matthew Gary Peschel.
All right. You can put your hand down. Sir, it is this court's understanding that you're going to be pleading no contest to the charge of stalking. That is a misdemeanor punishable by up to 1 year incarceration, a $1,000 fine plus court cost, and up to 5 years probation. You understand that, sir?
Yes, Your Honor.
You also understand, sir, do you understand what a no contest plea is?
Yes, sir.
All right. Two things about it I have to make sure that you understand. First thing is it means that you're not further desirous or wanting to contest these charges. You understand that?
Yes, Your Honor.
The second thing you need to understand is that for purposes of sentencing, the court would treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 14A4 District Court.
Yes.
All right. Counsel, the basis for the no contest plea?
Your Honor, both lack of recollection at that time and also fear of civil liability.
Thank you. All right. So, Mr. Peschel, to that charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes, Your Honor.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that?
Yes, Your Honor.
You understand you're giving up your right to appeal of right?
Yes, Your Honor.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead no contest to this charge?
No, sir.
Did anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily?
Yes, Your Honor.
Of your own free will?
Yes, sir.
All right. Court has been provided and has reviewed Michigan Department of State Police report for their case number 7897-24. Any objection to the court having reviewed that report?
None from the people, Your Honor.
No, Your Honor.
All right. Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court rule and would it be proper to accept this defendant's plea?
Yes, Your Honor.
You have, Your Honor.
All right. Court will accept the defendant's no contest plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A4 probation. Sentencing in this matter will be
February 27th at 9:30 before Judge Freshour.
February 27, 2025. What time?
9:30.
9:30 before Judge Freshour. Bond with its conditions will continue. Thank you.
Finally, this last case centers on Mr. Walker, who couldn't even follow a simple bond condition and now claims ignorance about THC in his system.
The recall.
Yeah.
Treatment? Oh, yeah. Court does call the case People versus Jeremy Walter.
Ashley Lenny for the people.
The judge. Portia Feaster, Assistant Public Defender, appearing on behalf of Mr. Walters. Mr. Walters, when you get here, please state your name.
Jeremy Walter.
All right.
Thank you, Judge. My understanding is this is a case that Mr. Walters had previously asked to adjourn to seek new counsel, to retain counsel. He has not been able to do that this time. I'd ask for a three-week adjournment so that he and I can sit down and talk, go over his case, and see about possible resolution, Your Honor.
Adjourn it, but what about his bond violation?
Yes, Judge, as it relates to his bond violation, I did speak to Mr. Walter about it in the hallway. Mr. Walter did say he was aware of the THC positive. He said he asked community corrections to send that off for further testing. He paid the $30 fee for that, as well as went to the therapeutic center that does his additional drug testing, and they did a second test.
When?
Within 24 hours of the positive test you received there, and he's expecting a result from them any day now. If the court wants to have those results in the near future, I'd ask the court to consider just adjourning it 1 week.
Well, I guess my question is he saying it shouldn't be in his system at all?
That's what he's saying, Your Honor.
Yeah, I did not knowingly ingest THC, but I do have a medical card, but
You have a medical marijuana card?
I do. It may need to be renewed, but I do have one. Oh,
This says you report not having one.
I don't think it's, I think it's expired, Your Honor. I
What?
don't think it's valid. I think it is expired, I believe, Your Honor. So I don't think he has a valid card. He may have a physical card, but not a valid physical card, Your Honor. My understanding of talking to him, like I said, my first time talking to him, Your Honor, he says he did not use any THC, and that's why he paid for the additional testing, and that is why he went and got the second test within 24 hours. So he should have some verification.
So you were just somewhere and this THC snuck into your system?
I don't really know how to.
Really?
I would.
No, hold it. Are you, so Mr. Feaster will explain to you how I am.
I did already.
So I just want to know, is that the story you're sticking to tell me?
Well,
What he's saying is, like we talked about in the hallway, if you did accident or choose to use marijuana in violation of your bond, it is best to tell him the truth today,
right,
and not say you didn't do it if you did do it. If you didn't do it, then you can.
And I didn't do it.
Okay.
I'm
So
100%
if we
confident that,
if
but I don't
we
know.
tested you today, your levels would go down for when that other test.
Yeah, or it'd be non-existent.
Or non-existent?
Yeah,
Okay.
I'm happy to.
Oh, yeah. Oh, you can be happy with that. You're gonna go over and get tested.
All right.
And we'll see what the results are. And then I'll make my decision as to what I'm gonna do with them.
Thank you, Judge. So you're going over the community questions right now. What Judge is telling you.
Yep.
I'm sorry. I noticed on a bond violation report that when the defendant went to do his initial intake, he said he didn't have money to test, which is why he wasn't tested that day. So we just confirmed that he does have money before he sent over there to prevent us having to come back and everything.
Do you have the funds to be able to test today?
I do.
He does, Judge.
Okay.
Thank you, Your Honor.
You're welcome.
Appreciate it.
All right.
Okay.
Okay.
He can head over and you'll let them know he's on his way. All right. Go test. Thank you.
Thank you.